The insolvency framework in Israel is somewhat different than in America. There is no comprehensive insolvency legislation. Actually, our legislation is comprised of separate acts, mainly 3 separate acts, 2 of which relate back to pre-statehood, since the British had the mandate over Palestine. Individual bankruptcies are governed by the bankruptcy ordinance. Corporate liquidations are governed by the company's ordinance. And corporate reorganization is governed by the Companies Act. These ordinances and act have been enacted over a span of several decades and thus led to inconsistent proceedings. Just for an example, we always ask the questions such as whether set-off rules apply equally in liquidation and reorganization. Why ask the question? Because there's a provision in the bankruptcy ordinance. There's no comparable provision in the Companies Act. So does it apply or does it not? We always have to labor over those issues. We even have acts, since we built it over decades, which most practitioners won't even acknowledge their insolvency nature. For example, I'm putting here on the slide the Agreements and Financial Assets Act of 2006, which only a minority of us know that it exists, and it's the equivalent to the bankruptcy exemptions under the Bankruptcy Code of financial instruments such as swaps, SWIFTs, and so forth, repo agreements and all those exemptions. Again, the enactment in separate acts led to the use of different terminology in between the acts, and that is sometimes a bit confusing for the practice. For example, the main officer taking care and administering the cases in individual bankruptcies is called the trustee in bankruptcy. In corporate liquidation, they are called the liquidator, and in corporate reorganizations, an administrator. We use the terminology of a bankrupt, but we don't use it with respect to corporations. We just call them the company debtor. There's sort of a stigma on an individual debtor called the bankrupt. Even legal vehicles such as a stay, a moratorium, in companies' liquidations and in individual bankruptcies, it's called the stay of proceedings. In corporate reorganizations, for some reason, we have called it a freeze of proceedings. And then everybody is confident that there's a major difference, even though there's not. Formal insolvency proceedings are sort of differentiated in our mindsets from mere, quote-unquote, financial restructuring, which many of us want to believe or wish to believe that they have nothing to do with insolvency. It's a mere restructuring, but that's all. Also, as a background, we should appreciate our corporate law to better understand also bankruptcy law. First and foremost, if we talk about corporate law in Israel, we should realize that unlike in the United States, we have no constitutional separation between corporate law and insolvency law. Whereas in America, bankruptcy law is under the federal system, under the Constitution, corporate law is part of state law. In Israel, there's no federal and state. We are a united system, small country. So corporate law and insolvency law are under the same legal regime. Speaking of principles of corporate law, our board of directors is subject to 2 main duties at all times: the duty of care and the duty of loyalty. The board of directors under the Corporations Act must act at all times to maximize the value of the corporation. There is no specific duty towards any specific constituency, such as the shareholders as such, or the creditors as such. It's always a duty to the corporation itself and to maximize the corporation's value. There is also no specific duty, at least not a statutory, explicit duty, to take certain actions or to file with the court upon facing financial distress. 20 years ago, I was studying for my master's at NYU Law School, and I was privileged to study a seminar given by Harvey Miller, who's sitting here with us today. Harvey taught me the importance of looking into legislative history and studying the history of law in order to appreciate what we're dealing with. So let's go back into the history of the legislation in Israel with respect to corporate reorganizations. Until 1995, actually there was no specific statutory law pertaining to corporate reorganizations. All we had was one section. At the time, under the Companies Ordinance, the Companies Act was not yet enacted. It was Section 233 of the Companies Ordinance. And this was since the times of the British Mandate. That provision was a general provision which allowed the court to convene shareholders or creditors and have them vote on a proposed settlement or arrangement with the corporation. It did not deal necessarily and specifically with insolvency. It meant any arrangement or any settlement that the corporation is seeking in any situation. The provision has a double majority requisite: a simple majority in person and a 75% in value of the shares, if it's a shareholders meeting, or the claims, if it's a creditors meeting, voting in the meeting. Of course, that section had no accessory tools such as a moratorium, provisions pertaining to financing during the procedure, or whatever. It was only convening a meeting, get to vote. That's it. And then came 1995. And realizing that there is a need for corporate reorganization legislation, the Ministry of Justice launched a very minor amendment to Section 233. We added subsection A1, which provided for court-ordered moratorium against all creditors. It's a discretionary moratorium. It's not automatic. It depends on the judge. The innovation in subsection A1 was that for the first time in Israel, we have a moratorium which includes also secured creditors, because under the corporate liquidation law in the Companies Ordinance, the stay of proceedings goes only against unsecured creditors. Secured creditors were not subject to the stay. Now, with respect to corporate reorganizations, the moratorium includes secured creditors as well. Again, there's an exemption which we imported from the US, and that is that the stay may be lifted if there is no adequate protection for the secured creditors. Indeed, this minor amendment, in practice, boosted the use of reorganization proceedings, and the practice started to catch up gradually. And then came 1999, 4 years later. In 1999, we reformed our general corporate law, abolished most of the Companies Ordinance, and replaced it by a new Companies Act. Some parts of the Companies Ordinance were left intact, those which dealt and are still dealing with corporate liquidation, with the hope that one day we'll reform all our insolvency legislation into one comprehensive act. So in this new Companies Act, Section 233, which was a catch-all section of the Companies Ordinance, transformed as is and became Section 350 of the Companies Act. So the moratorium, convening creditors' meetings, all that now lies in Section 350 of the Companies Act. Nothing beyond that. No provision whether you should appoint a trustee, not appoint a trustee. No word about that in the legislation yet. But then comes 2002. And to accomplish further reorganization legislation, we regulated the company's rules, the petition for settlement or arrangement of 2002. These rules regulated the information which is required to be disclosed to the court by a petitioner filing under Section 350. Importantly enough to notice is that Rule 14 of those rules authorizes the court to appoint an administrator for the case if it deems that that is what is needed. It's a discretionary authority. If the court wishes, they may appoint an administrator. If they do not, they don't need to appoint one. But in practice, we'll see that's what happened all the time, basically. So now, talking about the legislation, let's talk a bit about the actual practice. And I'm talking now on the period between 1995 to 2009, and then we'll get from 2009 to date. In those years, when you filed a petition with the court under Section 350, you usually accompanied that filing with the consent of the banks, which were the primary secured creditors, and already have arranged your reorganization financing agreements with them. It was very rare to file without seeking the bank's approval for the filing in advance. Not that under the law that was required, but that was the practice. The court issued a moratorium order and almost always coupled that with the appointment of an administrator. The Israeli courts are not accustomed to a debtor in possession regime, even though the law allows that. And then the administrator usually would soon enough auction the business as a going concern, take the cash proceeds, and distribute them to the creditors. That was basically the reorg pre-2009. In the middle, our capital market has changed. In 2005, the Knesset enacted amendments based on the public Bachar committee. The Bachar committee required the banks to sell their holdings in pension funds and mutual funds. It was sort of an anti-concentration trend in the financial market. The funds were acquired by investment houses and insurance companies. And sure enough, all of a sudden there was a large supply and search for investments by those pension funds and investment houses. And there was the rise of corporate bonds in Israel. The corporations issued corporate bonds, and the buyers were out there, insurance companies, institutional investors, and so forth. Those corporate bonds, which were hardly existent prior to 2000 in the market, those corporate bonds were issued largely unsecured. Until 2010, they were accompanied with only light covenants. That was since regulated by another committee, Chodek Committee, which requires institutional investors to look carefully into the covenants offered by the issuer prior to acquiring the bonds. Those bonds are traded in the secondary market, and distressed bonds traders, well, that's a practice that we have experienced only recently in the past 2-3 years, and we'll get to that probably later in the conference. It's also important to note that there is no active secondary market, for distressed bank debt. And then comes 2009. And since 2009, we're experiencing for the first time large-scale financial distress in billions of shekels in debt. Given the global crisis, there were liquidity strains in the market. So it was difficult to finance acquisitions of distressed companies. Thus, the auction practice wasn't that available. Also, the assets to be purchased were devalued, so that would provide a low return to the creditors if the companies were up for sale. The bonds were traded on the market. There was a potential to reorganize the debt, extend the maturity of the bonds, or convert them into equity. And sure enough, we're facing, for the first time in Israel, a classic reorganization, or as again we call it, debt arrangement. The largest reorganizations, thank you, the largest reorganizations were of holding corporations. In those reorganizations, we experience a dominance of controlling shareholders in the negotiations, something that you probably experienced less in the US. The creditors had a lot of expectations for some cash infusion by the controlling shareholders, and also they didn't want to lose too quickly the impact of the controlling shareholder given their business knowledge and their connections. For the first time in these reorganizations, a committee or committees of unsecured bondholders were formed. That was lacking in our practice before that. The negotiations took place without any appointment of an administrator, straight directly with the management and board of the company and advisors. There was no moratorium imposed. They never sought a moratorium from the courts. And also no specific provisions and no specific arrangements for interim financing. We did face attempts to delay formal proceedings as late as possible from both the corporation, its controlling shareholder, and surprisingly enough from the creditors as well, and we'll get back to that in a minute. And I think that we also experienced basically a learning curve that the creditors went through at the beginning, not really realizing and knowing how to deal with these reorganizations and how to negotiate in good faith and you know, at arm's length with the management and the board. It was sort of unheard of at the beginning. And over time, we gradually adapted. And again, it's worth noting that there's a gradual entrance of distressed debt investors into the market, and in the recent corporate reorganizations, their influence has been felt very much. This is a short summary of the big four reorganizations over the last 4 years. In 2009, we had Africa Israel. Then in 2012, we had Delek Real Estate, Delek Nadlan as we call it in Hebrew. And then in this past year, 2013, we had both IDB Holding and Elbit Imaging. And as you can see, the total debt is indeed in billions of shekels. And the package that the creditors eventually received in the various cases varied. There was some cash infusion, but in some of these cases, specifically Delek Real Estate, there was hardly any conversion, none at all actually, of debt into equity. The controlling shareholder kept the shares, and basically the debt was rolled over into new debt. In Africa, Israel, it was a cocktail of some cash infusion, some distribution of equity in subsidiaries, some offering of equity in Africa Israel Holding itself, and some rollover of the debt. And in IDB, eventually, it was basically back to a sale. It was auction, and there was a sale competition between the old controlling shareholder and two other groups who later merged and became one group, and eventually they won the auction and they just took over IDB. Again, partly by cash infusion and partly by converting much of the debt into equity in the subsidiary IDB Development. And Elbit is a classic conversion of debt into equity. Basically, the creditors received 98% of the equity of the reorganized corporation, plus some rollover of the debt. Anyway, the amendments that I mentioned earlier in my opening remarks are the amendments of July 2012. On the same day, the Knesset enacted both Amendment 18 and 19 of the Companies Act, both pertaining to corporate reorganizations. The gist of Amendment 18 is on this slide. It calls for a mandatory appointment by the court of an expert, a financial expert, nominated by the indentured trustees. The qualification of an expert is defined in the statute as having an expertise in financial or accounting matters, that when you look closely into it and into the regulation, it basically means that every other CPA in Israel is, quote unquote, a potential expert. Upon the inception of negotiations between a corporation and its bondholders for the material modification of the bondholders' rights, that's when the law mandates that an expert must be appointed by the court. The duty, the role of the expert is to assist the bondholders in negotiations and draft an expert's opinion on the proposed plan, and no voting on the plan is allowed prior to the expert's opinion. That's Amendment 18 in a nutshell. Amendment 19 goes further. It basically takes that one provision of a moratorium and expands it into a whole chapter concerning corporate reorganization. Now, finally, we provide the statutory tools that we missed in the past. It again rules for the comprehensive moratorium, subjecting another piece of creditors that there was a case law uncertainty whether they are subject to the moratorium in corporate reorganization, and those are all the suppliers who use in their contracts retention of title clauses. It was unclear in case law, and it went a few times up to the Supreme Court, whether these retention of title clauses should be subject to the moratorium in a corporate reorganization case. Amendment 19 put this argument to rest and said clearly, yes, you're subject to the moratorium. Again, the exemption for any secured claim from the moratorium is to the extent it can convince the court that it was not provided adequate protection. But Amendment 19 defined, for the purpose of lift of stay, explicitly that the standard to value whether there's adequate protection or not is the liquidation value and not the going concern value. Again, the statute now provides that it's up for the discretion of the court either to appoint an administrator or trustee or whatever we'll call that guy, or to leave the corporation under a debtor in possession management through the corporate reorganization. However, the statute does require that in the case where you go forward with a debtor in possession, that the DIP will be coupled by an appointment of an examiner, so to speak, to monitor from above the actions of the debtor in possession. So it's, let's go with the debtor in possession, but we're not sure about it, we're not clear, so let's take one half step backwards. For the first time, we're having an explicit provision allowing the court to approve the assumption or rejection of executory contracts, especially the assumption of executory contracts is something that was lacking from prior legislation, and that's an important provision in Amendment 19. There is no need, unlike 365B in America, there is no need to cure prior defaults prior to the assumption. And like in America, there is an invalidation of ipso facto termination clauses. With respect to financing in corporate reorganization, there is a priority for reorg financing. They are accorded either administrative expenses, or they may take a lien on companies' assets. That lien, to the extreme, may be pari passu with a with an existing lien or even a priming lien, but of course in those cases that's subject to the requirement of adequate protection to existing liens. Another provision, important provision in Amendment 19 is the classification of claims under the rules of substantially similar interests should be classified together, substantially different or different interests should be classified separately in separate classes. And for the first time, we have included in Amendment 19 a provision allowing the court to cram down a reorganization plan over the dissent of a class. For that purpose, you need to show that 50% of all claimants in all classes combined have approved, voted in favor of the plan, and also that the plan is fair and equitable to the dissenting class, which basically, without going into further details, calls for establishment of the absolute priority rule as we know it. But we haven't stopped there. 2013 came and there was a public cry over corporate debt arrangements, and then our new Minister of Finance, Mr. Yair Lapid, and the former governor of the Bank of Israel, and perhaps soon to be the deputy governor of the Federal Reserve, Professor Stanley Fischer, appointed a public committee chaired by Mrs. Yael Andoren, the Director General of the Ministry of Finance. And this committee is to review the public debt arrangements and recommend improvements in the process. The deliberations of the committee are still pending, so we'll see what happens. Anyway, before concluding my talk, I wish to draw the attention to the fear factor concerning insolvency in Israel. Our separate legal evolution led, as I mentioned earlier, to different mindsets and approaches towards the various proceedings. We are very wary in the practice from the very term insolvency. Insolvency is always connoted in Israel specifically with liquidation, with the demise of the business. It's a negative stigma. There's an apprehension from formal or strict insolvency-associated proceedings. A reorganization with moratorium seems to the practice to be a bad thing. Without moratorium, it's okay. It's not as frightening. Weird to me, but that's how it goes. There's always a tendency to color debt reorganizations or refinancing as somewhat different, as if they are outside the scope of the insolvency practice. There are attempts to depict the process as a mere capital market restructuring without labeling the process formally as a reorganization process, lest it would be, again, linked to insolvency, God forbid. And that led to creativity in remedies requested. For example, in the Elbit case that I mentioned earlier, no moratorium, there are negotiations. But nonetheless, one of the secured claims by one of the banks was pressing hard on the corporation. But they didn't want to ask for a moratorium because they were afraid of the concept, and maybe the judge, the court, will, with the moratorium again, appoint an administrator, and no one wanted an administrator. So what did they do? They went like regular civil procedural litigation and asked the court, without a comprehensive moratorium, to issue an injunction against the bank from foreclosing on the collateral. I mean, trying to receive the result without calling the explicit name of what we're actually asking. But if you come to think of it, it's not about the undesired or the wrong guys. It's not about the courts. It's not about the official receiver. It's not about the trustee or administratorship. In the end, it's all about control. The control factor concerns the controlling shareholder who wants to still call the shots. It's the board of directors who wants to be there and are afraid to be replaced by a trustee. It's the creditors as well, who want control over the process, and they don't want a judge or a neutral party to tell them what to do. And of course, it affects their lawyers and their advisors. That's what's behind all of this. Where does all of this lead the practice? it leads the Israeli practice to a culture where experiencing insolvency is really a pain. The debtor is tainted. The credit ranking drops to D, but when? For example, in the IDB development case, there was no administrator appointed, and then the credit agency Ma'alot did not drop the credit ranking of IDB development, but did state that to the extent a full-scale trustee or administrator shall be appointed, at that point, they will drop the ranking to D, to default. So if you're in a 350 proceeding without an administrator, without automatic stay, then you're not a D. If there's an administrator, if there's a moratorium, you're a D. Why is that? Interesting. The controlling shareholders become a persona non grata. There are large emotional reactions. And we must mention this to conclude. The press and media coverage in Israel of these reorganizations is way overreacting and creating a whole mess out of the process. That's the background I wanted to provide you. And now I will invite my friend Troy McKenzie to introduce us all to Chapter 11. Thank you.
Good morning. It's an honor and a privilege to be here. And as Professor Hahn said, my job this morning is to give an introduction to Chapter 11 of the United States Bankruptcy Code, the reorganization chapter of the Bankruptcy Code. This is an impossible task, certainly an impossible task to do in 25 minutes or a half hour. So my goal today is really to do three things. First, to give a very brief sketch of U.S. bankruptcy law and where Chapter 11 fits in U.S. bankruptcy law. Second, to talk briefly about the basic stages of a Chapter 11 case. And then to essentially explain the origins of Chapter 11 and some of the policy choices made by Congress when it enacted Chapter 11 about 35 years ago. So first, U.S. bankruptcy law and where Chapter 11 fits in U.S. bankruptcy law. U.S. bankruptcy law is contained mostly in the Bankruptcy Code, which takes up an entire title of the United States Code, which is the compendium of federal statutes. But having said that, the Bankruptcy Code is not really the only source of law in a corporate reorganization proceeding. Because, as Professor Hahn said, the United States is a federal system, state law plays a significant role in the process of enforcing and collecting debt, and also simply determining the validity of debt, determining whether or not someone has a claim in the first instance. So looking to state law, even though federal law governs a bankruptcy proceeding, is common in the United States. Now, the Bankruptcy Code has several chapters that deal with different kinds of debtors and different kinds of proceedings. There is Chapter 7, which is for the liquidation of both individual and also corporate debtors. And in Chapter 7, a trustee is appointed to liquidate the assets of the debtor. There's Chapter 9, which deals with municipal debtors, Chapter 12, which deals with family farmers, Chapter 13, which also deals with individuals, Chapter 13 for individuals, Chapter 15 for cross-border cases, and then finally Chapter 11, which is the reorganization chapter. Now, here are the basic stages of a Chapter 11 case. The first is the commencement of the case by filing a petition for relief with the bankruptcy court. Now, this is incredibly significant because the filing of the petition, the voluntary filing of the petition by the debtor, is an order for relief. And what that means is, upon the filing of the petition, any further proceeding to collect, commenced or continuation of any further proceeding against the debtor is enjoined. This is the automatic stay. The debtor doesn't have to request this separately. The court doesn't have to rule on it. Simply at the moment the case commences, further proceedings against the debtor are automatically stayed. And this is a very powerful feature of Chapter 11. It is also a very powerful incentive for a debtor to seek relief in Chapter 11, because it can mean, for example, stopping a pending foreclosure or stopping some other further collection action by a creditor against the debtor. The second stage is continuation of control of the firm's operations by the incumbent managers as debtor in possession. Now, this means there's no trustee that is appointed as a matter of course in a Chapter 11 case. In appropriate cases, a trustee might be appointed, but the practice really is only limited to those cases in which there is a suspicion of fraud or abuse, such that there is a view that the debtor in possession cannot, in fact, continue in control and in possession of the firm. The next stage is formation of committees. For example, a committee of unsecured creditors, an official committee of unsecured creditors. The code provides for the possibility of the formation of other types of committees, perhaps an equity committee, although that is rare. And then after formation of a committee, negotiation among the debtor, creditors, other constituents regarding the resolution of the debtor's affairs, which will then lead to the debtor's proposal of a plan of reorganization, including disclosure of adequate information about the plan's contents, so that the plan can then be sent out to creditors and interest holders to be solicited for acceptance or rejection. At that point, voting occurs, and voting under Chapter 11 requires each class to accept the plan. Acceptance requires a double majority, more than one half by number, 2/3 by amount of claim in each class. And then finally, confirmation of the plan by the court and the debtor's emergence from bankruptcy as a reorganized entity. The court can confirm a plan even over the objection of a dissenting class under a cram-down proceeding, as Professor Hahn mentioned, and that requires the court to find that the plan does not discriminate unfairly and is fair and equitable to the non-accepting impaired class, so long as there is at least one impaired class that has accepted the plan. So that, in broad brush, is sort of the stages of Chapter 11. But what I'd like to do in my remaining time is to talk a little bit about some of the policy choices that went into the creation of Chapter 11 and three specific issues upon which Congress made policy choices when enacting Chapter 11. So here are the three issues. The first is whether the debtor and its managers should remain in possession and in control during the case. The second is whether the administrative state, government agencies and so forth, should play a large or a small role in a bankruptcy proceeding to reorganize a firm. And the third is whether a bankruptcy statute dealing with reorganization of firms should be relatively flexible and open-ended, or specific in its requirements for different types of debtors, different categories of proceedings. And on each of those policy choices, Congress made a decision at the time the Bankruptcy Code was enacted in 1978 And those decisions are ones that we will discuss in more length throughout the rest of this conference. So in order to explain those policy choices, I want to give a little bit of background about the law before Chapter 11 was enacted in 1978. Now, before 1978, there was not a single provision for corporate reorganization in the United States. Instead, there were three. There was Old Chapter 10, Old Chapter 11, and Old Chapter 12. For sake of clarity, usually these chapters are denoted in the literature with Roman numerals so that they aren't confused with modern counterparts. Old Chapter 10 was really the provision that was designed for corporate reorganization. It was designed for large companies with secured debt and with publicly held securities. Old Chapter 11 was intended for the readjustment, or as the word was used, the arrangement of the debts of smaller businesses. This was really for a so-called mom-and-pop business. This was not for a large business. And Old Chapter 10 was designed for the restructuring of holders of real property. Now, really, in the history of American bankruptcy law, before Chapter 11 was created, new Chapter 11 was created in 1978, there was significant tension between the provisions of Old Chapter 10 and Old Chapter 11, with a lot of litigation about whether a debtor qualified for one chapter or the other. Now, why was there so much contention about this question? Well, it will explain the contention if I describe what would happen under each of the old chapters. If a corporate debtor filed for bankruptcy under Old Chapter 10, the court was required to appoint an independent and disinterested trustee. There was no debtor in possession. Now, of course, the trustee was likely to retain the present managers of the firm to help run the firm, but control rested in the hands of the trustee. Old Chapter 10 also required the active participation of an administrative agency, in this case, the Securities and Exchange Commission. And the view of the SEC's role in Old Chapter 10 was that the agency was supposed to be an expert. It was called in to review the debtor's business affairs, to make a report of management practices, and to render an opinion about the debtor. And although this role was described as only advisory, the agency had a tremendous amount of influence in cases under Old Chapter 10. In fact, when a plan of reorganization was sent for voting, the plan could not be sent without the Securities and Exchange Commission's view of the advisability of the plan. It was, in a sense, an expert called in each of these cases. It also had the right to appear and to object in a case. So as you can imagine, many debtors sought as much as possible to get away from this proceeding, and the alternative was Old Chapter 11, designed again for small businesses, mom-and-pop businesses, not for large firms. The attraction of Old Chapter 11 is that there was no trustee automatically appointed, there was a debtor in possession, there was no Securities and Exchange Commission, no administrative agency to have to deal with. The limitation was that the debtor could not substantially restructure its secured debt, and there were other limitations that made Old Chapter 11 less flexible for large firms. But leading up to 1978, debtors had found, and their lawyers had found, ways around those limitations. For example, it was interesting to hear something Professor Hahn mentioned. One of the common ways of getting around the inability to restructure secured debt was to ask the court under Old Chapter 11 to enjoin the secured creditor from foreclosing, which effectively brought the secured creditor to the table, even though the statute did not provide for restructuring of the secured debt. Now, in 1978, Congress enacts Chapter 11, and what does Congress do? Well, on each of the policy questions that I highlighted a few moments ago, Congress made some very clear choices. First, Congress decided to give more control to debtors in business reorganization cases. The statute explicitly provides for the debtor in possession as a matter of course. The debtor in possession, with limited exceptions, has all of the rights, the powers, and the duties of a trustee, so that now, as I said, the appointment of a trustee is the exception and not the rule in Chapter 11 cases. Now, the statute also gives the debtor something that is quite powerful. It gives the debtor the exclusive right to formulate, to propose, and to solicit the acceptance of a plan of reorganization for a period of time at the beginning of the case, which is commonly referred to as the exclusivity period. This period could be, and often is routinely extended by the court. So again, this was a policy choice by Congress to give a great deal of control in not just the operation of the business, but the operation of the planning of the case and the running of the case to the debtor. The second policy choice Congress made was to minimize the role of the administrative state in corporate reorganization cases. The Securities and Exchange Commission was essentially kicked out of the process. There was no more special advisor investigating the affairs of the debtor, and instead a new and more limited agency was eventually created, which is known as the U.S. Trustee Program, to serve as something of a watchdog in Chapter 11 cases, in all bankruptcy cases actually. And on that third policy choice, whether or not to have an open-ended or more specified bankruptcy provision, Congress opted for openness and flexibility. There is just one form of business reorganization, it's Chapter 11, and it can be used by a wide variety of firms. Big businesses, small businesses, everything in between. What Congress did was to collapse old Chapter 10, old Chapter 11, and old Chapter 12 into new Chapter 11, a single chapter that was meant to capture essentially all business cases. In fact, I shouldn't even say all business cases because individuals are permitted to file a reorganization under Chapter 11 as well. There were also very few limitations in Chapter 11 on who may be a debtor. So, for example, there is no insolvency requirement in order to file for relief under Chapter 11. Now, it may turn out that a solvent debtor would not truly benefit from relief in Chapter 11, but there is no statutory solvency requirement in Chapter 11. And over the years since, there have been other innovations that have occurred in Chapter 11 that have been approved by courts because they do not conflict with the code. So, for example, although the initial intention of Congress was that the case would start upon the filing of a petition, there would then be negotiation, there would then be the creation of a plan, there would then be voting, now it is common for courts to approve so-called pre-packs or pre-packaged bankruptcies in which negotiation and plan formulation occur before the case is filed, and what is essentially filed with the court is a package of documents that encompass an entire case in one fell swoop. Another example of the flexibility of Chapter 11 over the years is the creation of plans of reorganization that do not truly reorganize the debtor but simply liquidate the debtor. And that is a development that courts have also accepted. The other development is that sometimes courts have allowed reorganization for debtors to deal with debts other than the usual financing debts, contractual debts. Tort liability, for example, is one reason why debtors may reorganize, and in the United States right now, it's common for companies with large asbestos liabilities to use Chapter 11 essentially as a form of mass litigation device. And all of this has been able to fit under the guise of Chapter 11. So I want to close by discussing a little bit some of the ways in which Chapter 11, as of 1978, has changed, so that if you were to look at the bankruptcy system today, you would see that on those three policy choices Congress made, there has been some shifting over the years. Now, some of that shifting is because Congress has decided to change matters. Some of it, frankly, is because the world has changed. The world of finance has changed, the players in the system have changed, and that has caused change in Chapter 11 as well. Now, with respect to administrative oversight, essentially there has been no serious change since 1978. The policy choice is still to have a very limited role for the administrative state in corporate reorganization cases, although there are recent signs that the U.S. trustee program has become more aggressive with respect to its role in bankruptcy cases. On the other policy choice I mentioned, the degree of debtor control, there has been alteration by Congress over the years. Now, there's still a debtor in possession. That has not changed. It's still the norm not to have a trustee in a Chapter 11 case. But there are now more limitations on the debtor's exclusive right to propose a plan. In 2005, Congress included what is essentially a drop-dead date before which the debtor must propose a plan or lose its ability to retain exclusivity over plan proposal. So now, rather than being able to continually extend exclusivity, a court has a limitation no more than 18 months after the commencement of the case. And this is one reason, not the only, but one reason that it is now more common for there to be competing plans of reorganization in Chapter 11, which was something that was really very uncommon up until recently. And combined with changes in the credit markets, including the rise of hedge funds and distressed debt investors, this has made the process of negotiating and resolving financial distress in Chapter 11 much more complicated. More players and more limitations on the freedom of the debtor mean a more complicated process. On the last policy choice I mentioned, whether to have openness and flexibility or a more specified statute, well, there's been serious doubt, I think, over the years as to whether Congress retains confidence in its choice back in 1978 for a relatively open-ended statute. Over the years, Congress has added many more details, many more restrictions in Chapter 11, so that the code is not quite as flexible as it was back in 1978. Now, to be sure, there is still only one Chapter 11. But in some ways, Congress has revived some of the old distinctions that existed before 1978. There is now a small business provision for Chapter 11, which is intended to speed the process up for small businesses. There are specific provisions for firms with single asset real estate holdings that limit the ability of those firms to have as much freedom of movement as other firms do in Chapter 11. Now, other changes that have occurred over the years are not necessarily changes with respect to policy choices, but simply changes by those in the system who have turned their emphasis to provisions of the code that were perhaps not as prominent at one time, but are now common features. So I want to highlight one area of change, and that is the use of asset sales. We've been talking about corporate reorganization. I talked about the traditional form of Chapter 11, where there's negotiation with respect to a plan, there's solicitation and voting of a plan, but the reality is that today, much of the action occurs far earlier in the case if, for example, the debtor sells all or substantially all of its assets during the case rather than engage in a traditional reorganization through a plan. And this is under Section 363 of the Code, which permits the debtor in possession to sell assets outside the ordinary course of business, but with court approval. And the classic example was always when an asset was considered valuable but rapidly depreciating in value, such that it made more sense to sell it now and bring value into the firm to be distributed later, rather than to wait and see the value of the asset diminish. And in some of the largest Chapter 11 cases in the past several years, including, for example, the automotive cases, GM and Chrysler, the use of a 363 sale was the most prominent feature and, to some extent, the most controversial feature of those cases. So that, in 30 minutes, is an overview of Chapter 11. There is, as you can imagine, tremendous amounts of detail that I have decided to gloss over because of time. But during the course of this conference, each of the pieces of detail that I left out will be part of the discussion. But what I wanted to leave you with is, again, thoughts about those three policy choices that I mentioned. The extent of debtor control, the extent of influence of the administrative state, and whether to opt for flexibility and openness or more detail and restrictions. Because in truth, those are three policy choices that any system that deals with corporate insolvency has to reconcile. This is not something that only the American system has to deal with. It's something that I think the system in this country has to consider as well. Thank you very much.